All right, let's start. Hi everyone, thanks so much for joining us today. Great to have you here. Today is a really special webinar because we are joined by one of the most respected figures in US immigration policy, Efrain Hernandez. Efrain spent over 30 years in USCIS and the former INS. Basically, he's one of the people who actually shaped the US immigration rules. So today, he's going to walk us through employment-based immigration, trends, and what may come in next, straight from the original source. If you have any questions at any point, drop them in the chat. We'll pull them up for Efrain and Jenny during the Q&A section. Just a quick reminder, we are a bit tight on time today, so we may not be able to answer every question. If you have something you'd like to ask, please send it in the chat as soon as possible. And if we don't get your question during the sessions, feel free to scan the QR code and join our WhatsApp and WeChat group. We will continue answering questions there. Before we dive in, please allow me to introduce Beyond International for those who are new. We are an SEC-registered cross-border investment and immigration platform, and we've issued over 30 real estate funds in the US, with more than 600 million invested. We also follow US immigration policy very closely, so webinars like this help us bring you the latest update and the clearest explanations. We also have 2 office buildings, one in Houston, one in Irvine. And if you are interested to learn more, feel free to check our official websites and platform. We update them regularly with the latest news and project updates. So for more contact info, please feel free to scan the QR code or take the screenshot and join our WhatsApp or WeChat group. You can also get a free recap, a full summary, and today's PowerPoint after the webinar. Or if you prefer something more personalized, you are more than welcome to schedule a free one-on-one consultations with one of our advisors. So give us audience some more minutes to take the screenshot on this PowerPoint and feel free to contact us anytime. Okay, now let's jump into our project. Let me quickly introduce our new Hawaii Big Island Rural EB-5 project. It officially broke ground on September, so construction is already moving. For investor protections, EB-5 funds are in a first-line senior loan position, which basically means EB-5 investors are first in line. The structure is very simple: 3 years investment plus a year exit window and another year backup. So it is a clear 3+1+1 timeline. Right now, about half of the spots have already been reserved. The focus of this project is really 2 things: keeping the green card safe and keep the money safe. That's what investors care about most. And this is also the 12th project managed by the Beyond Regional Center. And so far, our approval rate has been 100% across all projects. We've helped more than 700 investors get their green cards, and over 100 million has already been returned to EB-5 clients. If you are interested in the Hawaii Rural Project, it's open now. Feel free to, again, scan the QR code and reach out to our team for more info anytime. And we are also happy to have Jenny, our founder and CEO, join us today. Jenny focuses on global asset management and leads all the immigration and compliance initiatives for our firm. She even received the International Contribution Award from IIUSA, the leading EB-5 industry association in the United States. Hi, Jenny.
Hi, I know everyone is waiting for Efrain. Our host mentioned about we have EB-5 project. We are actually called the EB-5 NCE manager. But my background actually exactly came from, I was a H-1B student.
Oh,
Came here in F1 visa and then H-1B, and like a lot of people, um, in the processing the immigration process, I got received my green card through EB-2 NIW program, and it it happened. It was about 30 years ago, and I know it has changed a lot, for the H-1B program and all the professional immigration category has changed a lot. The landscape has totally different from that time. But and if the immigration is, if I understand, as just as before, investment immigration, professional immigration are always very hard. That's why I will always have to rely on an expert to provide us more guidance. Always in any situations, we have to pick out the best way to design and plan our immigration path. I'm so glad today we have invited the expert in this area, former, USCIS insider, and someone have written a lot of professional immigration guidelines. Efrain Hernandez, and Efrain, welcome.
thank you.
Uh, Hi, yeah, thanks for the nice introduction. I'm happy to be here.
Yeah, like exactly what Jenny said, Ephraim is our big highlight of today. And with that, Ephraim, the floor is yours. Please share your screen now.
Okay, let me switch over here.
Mhm.
There, you see that okay? Oh, wait, no, sorry. There, now do you see it?
Yes.
Yes.
Okay, let me get out of this initial screen. Okay, well, that's me. You already heard all about me. Um, there we go. I was frozen. I was staring at myself. I was frozen, but it looks like I'm working now. You already heard all about me. Yeah, the last 32 years, I've been doing immigration law and policy. The last 20 years have been focused exclusively on business immigration, employment-based immigration. So that is my true expertise. Although with the previous 12 years, there basically isn't anything that I haven't done at some point along the way. Some of those things have changed. Like for example, I used to actually supervise the EB-5 back in the late 90s, and of course, it's not the same now. So, but yeah, but there anyway. And right now, I'm on, you can see there, I started my own consulting firm, my own practice, which I'm enjoying a lot. I get to do things like this. So, yeah, thank you. Nobody wants to hear that, so let's move on to some more important stuff. Excuse me. So here's what we're going to be looking at today. I want to do a brief summary of some of the options that I think are relevant to this group.
Recording in progress.
Okay, now we're recording. Brief summary of some of the options that are relevant to this group. Um, some of the new changes that are coming or already happened. Some of the trends we're seeing in adjudications, and finally, just how do we navigate this very difficult and probably getting more difficult all the time environment. So hopefully we get a lot out of this. Let's see here. Yeah, so starting out with a brief summary of these options. This is what everyone wants to get, right? The approved stamp. Okay, I don't want to focus too much on non-immigrant categories because I understand that, at least I was told that this group is pretty familiar with this stuff. I mainly wanted to highlight this. Two things. One is for the L, for everybody. Um, it can kind of be, there's a thing called a new office L, which is basically what it sounds like. It lets you open up a new office in the US of an existing business that you have abroad. So if someone's entrepreneurial, they have a business in China or India or anywhere, you can, doesn't have to be multiple. You don't have to share nationality with the business. Um, you can do that. And after a year, you just need to be supporting a manager, basically, is what it is. So, and then you get an extension into the regular L time. So that's something, people don't think about that a lot. It's worth looking at. The other thing I wanted to kind of briefly mention uh, on the E and the E3, probably most of you know the E investor trader, there needs to be a treaty between the US and the country, which particular country. There isn't one with China. There is one with India. So that's a good one because there are not minimum investment amounts. It's basically just will a company be generating enough income? Let me rephrase that. More income than would be necessary just to support yourself. So it's basically like job creation, but it's a much lower threshold than you would typically see for investment issues. So that's an option. And even for those of you who are in China or Chinese citizenship, if you happen to have dual nationality or dual citizenship, just by any chance, you can use that other country. It doesn't have to be, you can choose which country you want to use. Um, Same thing for the E3. E3 is something that most people don't think about or know about. And it says Australian, which is right. You need to have at least one of your nationalities has to be Australian. So if you're somebody who has access to that as a relative or some business or something, that can sort of be a backdoor in because it's basically the same as an H-1B, but there's no cap. So it's not, and of course now with the increased fee and the $100,000 fee and all that stuff that's going on, you wouldn't have to pay that. So I just wanted to flag those. Like I said, I don't want to spend too much time going through these. Um, if anybody has specific questions about any of these, feel free to ask them in the chat and I will get to them. So the next,
J'aurais like tutti in English interessano.
okay, we can hear somebody there on the
Is someone asking the questions? If you want to ask the questions, you can leave the question in the chat or waiting for our Q&A sections. Thank you so much.
Okay, yeah, thanks. So the first one that we really do want to look at is the EB-1A. EB-1A. Basically, the EB-1A, for anybody who doesn't know, EB stands for employment-based first preference. So first is the one, and extraordinary ability. So you can think of A means ability. So EB-1A. It doesn't require an employer. You could self-petition. Doesn't require a job offer. Does not require a labor certification. So it's attractive in that regard. The hard part is that it's a very high standard. To qualify, you have to show that you are the one of, which is the very small percentage who have risen to the very top of your field. So it's really for the cream of the crop, the very top of whatever your field might be. Where you do have some leeway there is in identifying the field. It doesn't have to be, anything. You can characterize your field differently. You can say this is really engineering, or this is really, some subset of computer science or something. And sometimes if you can make that argument to narrow the field, I think it's easier to then show yourself as being the top of that field because it's a smaller field. You can't always do that, but it's just something to bear in mind as you're doing these. You also have to show that you're going to continue to work in the field. Sometimes for people who do not have a petitioner or job offer, the things I was mentioning, it can be a little bit harder because you're just saying, yeah, I want to keep researching this topic that I've been researching all these years, or I want to keep doing this, entrepreneurial thing, or whatever. But it's just a teeny bit harder to show it, but it's not a huge deal. And also the big one is you have to show that you're going to be the work will benefit the United States in the future. And that's not too bad. It's mainly like even for somebody like a coach, like an athletic coach, saying, well, I'm going to be coaching American kids, and the American kids will get better at the sport. I mean, it can be something that simple. It doesn't have to be. It's not like the EB-2, which is a lot more involved, and we'll get to that in a minute. Moving on. So the first, what USCIS does a two-step process, which you're probably familiar with. The first step is objective, and the second step is subjective, really. Or quantitative for this one versus qualitative, which we'll get to. I don't think anybody here has a Nobel Prize or a Pulitzer Prize or an Oscar, Academy Award or anything like that. But if you do, then that's it. That's enough. You got one of those. You don't have to worry about the rest of the things on this list. But since most people don't, you need to get 3 out of the 10. And I won't read them all here. You can see them. Um, let's see. The other thing here is that if there's one or more aspects of these lists that don't really apply to your field, you can use what's called comparable evidence. So you'd have to show, for my field, the work I do, that these things just don't exist. There isn't a journal, there isn't, that kind of thing. Where you typically see it is with entrepreneurs, where typically they're not paid a salary. And in fact, to get funding, paying yourself a high salary is probably a big mark against you in terms of getting that funding for an entrepreneur. So when you see here high salary or remuneration in relation to others, that would be that we see it a lot where people say, well, it's a startup, I'm an entrepreneur. That's not how it works. We don't pay ourselves big salaries. But look at my stock options, my ownership of this company, the potential value, and that's where you say, well, relative to others, that's it's comparable to that, and so you'd be making that argument. Of course, that gets difficult too sometimes because for a lot of startups, the shares might not be worth a lot, at least initially. That's just something to think about. Yeah, let's go on to the next one here. Now, again, I was saying 3 out of the 10, showing that you have 3 out of the 10. Oh, actually, I'm sorry, let me backtrack. A lot of people want to say, well, I can get 5 or I can get 6, and it's going to be stronger. Or, it's a little bit of a stretch with these other ones, but I think they probably could fall within these. So I'll probably be in better position if I check more of the boxes, right? That isn't really true, and I think I mentioned this in one of the later slides. It just makes the whole thing look it weakens your overall case, and the adjudicator is going to see these other ones that are like a stretch or kind of weak, and then it's going to kind of feel like, well, maybe everything else is too. It sort of plants a bad thought in their mind, a negative idea that, oh, this isn't that great because look at these, this, that kind of thing. So it's almost better to just focus on only 3, and if there's pieces of evidence or criteria that could go either way, it might fit in more than one, to sort of consolidate those. So you're making the 3 that you have stronger instead of spreading it out, thinner. So that's just every case is different, but it's just something to think about. So again, like I said, the factors, it's a sorry, I get stuck with these words, quantitative criteria. So you either have them or you don't. Sometimes you'll see adjudicators while they're reviewing the 3. It's just basically supposed to be almost like a checklist. I've got 1, I got 2, I got 3. They'll question you or do an RFE. So, well, you submitted these articles, but they don't show sustained claim because the last article was in 2019 or something. They shouldn't be saying that at that point of the adjudication. What they might want to say is like, for example, you're in this media you submitted, 4 articles that were talking about you in some piece of media somewhere. But we don't know, we never heard of this newspaper or this journal. We don't know what it is. We don't know that it's that impressive. Because if you remember back to the list, it's, yeah, here we go. It's major media. So they might say, well, that's show me that it's major media, right? That would be okay at that stage because they're still trying to meet the 3 and 10 before they go on to the next phase. But they shouldn't be asking you about sustained acclaim. Are you really that great? Are you really the top? They shouldn't be doing that until this next step here, which is the final merits. And here, after you've shown that you have 3 out of the 10, then they do the whole picture, the totality of the evidence. This is where it is subjective and it's quantitative. I'm sorry, qualitative, not quantitative. These are the words that are used in the regs and the statute and the guidance and everything else, qualitative versus quantitative. It's just me that I get hung up on these 2 words because they're so similar. So sorry for that. But yeah, this is qualitative. So the adjudicator will look at the whole thing, say, well, let's say your citations kind of articles you stop being cited so frequently several years ago, so you haven't really shown me that it's a sustained merit, or lots of people have done what you've done, so I don't think it's really the very top of the field. Things like that, where it's just I don't see it. And it's almost unfair. I don't want to say it's unfair, but in a way it is, because it's giving the adjudicator 2 cracks at your evidence. Because you'll see the first one and say, well, this isn't really a major journal or whatever. And then they'll get the overall totality at the end and say, well, yeah, even though you had this major journal, it just doesn't seem that important. Something like that, or the circulation isn't that great. Or, and I know a lot of people do this, or I shouldn't say it that way. Not that a lot of people do it, but I know that these exist. Is basically you can pay journals to publish your articles, paid media where they talk about you. USCIS is aware of those. They look at it, so it's probably not going to work. And again, it just undermines the rest of your case. Also, they use something called something like a heat score, something like that, where in the case of that journal, say how many other journals cite your article and how many cite that, and you can say like, wow, this gets a lot of citations across various publications. It's very influential, this article you wrote, versus, well, you wrote an article, but nobody ever cited to it. Nobody ever referenced it in any other publication or anything. So that would be a mark against it. But that, going back to what I was saying, that they know, and they'll just see, well, okay, you got this article, but didn't do anything, right? So it's not important, it's not major, your work isn't that great, that kind of thing. That's where that comes in, is this step. Move on here. Actually, I'm going to skip this for a second. So, in terms of tips for EB-1A, it's good to think about, for the final merits, the theme of your career. I started out here, then I did this big thing. It's kind of like a narrative. It's a story. It's progression. Like, now I'm at the top, right? It's like a success story. So you want to tell that story. It's looking for continuity. Like I said, kind of go up and up and up, better and better. And the scope and reach, again, like I was saying with the articles, how influential is your work? Is it just you and your company that benefits from it? Is it like a lot? It's been adopted as an industry standard, that kind of thing. How influential? What's the scope of it? And something that you don't see a lot of people do, and I think it's very helpful for reasons that we'll get to in a minute, is using charts and graphics. So let's say you've been cited a lot, and every year you get cited a little bit more, or you say, have a little, like an XY chart showing here's my progression of, citations, or here's the valuation of my different startups over the years, or like, they took off, or that kind of thing. It's very easy to digest, and it's very easy then for them to see a progression. It's a visual tool. They can always look at in-depth, the materials you submitted, but that kind of gets it right in front of them, and they see it. Now I don't want to say you plant the idea, because assuming you are qualified, but it lets them get that idea in their head. Yeah, I see it. Yeah, and then when they're looking later on at the 800 pages or whatever documents, they're already kind of thinking, well, I saw it earlier. Yeah, so this makes sense. What I'm reading here, because I saw the progression over there. So charts, graphics, be creative, make it easy for them to get the point of what you're trying to say. I already mentioned earlier about, well, actually, the adjudicators do it. And one of the reasons the adjudicators tend to mix the two steps is because petitioners tend to mix the two steps. So you'll see long letters, sorry, where you'll be talking about the 3 and 10. Here's how I have this, here's how I have this, here this. But in the same letter, in the same section, they'll also say, and this was really important because everybody adopted it and had this influence. Like, that's not the place to do that. It's do that later in a separate section where you're addressing how important, how good, the quality. And again, I already said this. Don't use low quality evidence. You see those big 800-page files. A lot of it can be like marketing materials for a company. You see a lot of time website printouts, or maybe an article that was more about the company and not really about the person. Those are limited use, and that's how adjudicators look at those. So again, you have enough of those in there, it starts to bias is probably a loaded word, but it starts to bias their judgment against you, not in the way you want it to be. So just, don't do it. But you feel like you need to, because I got to have everything in there, right? I can't take a chance that I missed something, I forgot something, or they don't know everything there is to know about me. It's a natural tendency, but it's honestly not the best way to present your case. Excuse me. Now, going back to where I was a second ago in the EB-2, as Jenny knows, she was mentioning, it's EB-2 is for most positions, you do need a labor cert from the Department of Labor, and as a prerequisite to filing with USCIS. That is it's a difficult process. The perm process with the Department of Labor is difficult and it's time consuming. So if you can avoid it, that's great. The national interest waiver, that's what it does. It lets you bypass that. And similar to the EB-1, you don't need to have a job offer. You don't need to have a labor certification. You can self-petition for yourself as an EB-2. It's a slightly lower standard than the EB-1A. Different factors, of course. You need to show it's the same two-step process, but here, whereas in EB-1A you had to show you were the very top of your field, here you're showing that you have exceptional ability as opposed to extraordinary ability for the other one. And exceptional ability just means like a level of expertise above what you would ordinarily encounter. So that's much lower than very top of the field, right? The other way to do the EB-2, if you're not exceptional ability, is to have an advanced degree. You could have a master's or higher, or if you just have a bachelor's, you could still show it if you've got 5 years of what they call progressive experience in the field. So it can't be like, well, I'm an engineer, but I had 5 years of progressive experience as I don't know, something else. It's got to be in the field that you're saying you have this merit. But you can do that. So that's one way a lot of people do it. You still have to show, though, that the work you're going to be doing here These are the three factors. You can see them here. It's got substantial merit and it's got national importance. That you are well positioned as a petitioner to advance this endeavor. So, like, this would be like where you'd have like a business plan showing how crucial you are to the business plan, or if you've had previous successes in the field, you can say, well, I did this, I did that, and these were successful. That's why I'm the person who's going to do this. Um, so showing you're the right person for the job, basically. And of course, the final step, which is national interest, that's what it's called, is that it's beneficial to the U.S. to waive the job offer and the permanent labor cert requirement. For someone like an entrepreneur, it's pretty easy actually to do that one because you're creating jobs and you can say, well, hey, I'm creating 10 jobs. So the whole point of the labor certification is to show that I'm not taking jobs, I'm not displacing a U.S. worker. Well, clearly you're not because you're getting 10 more workers jobs. So that's kind of an easy one there. It's one of the easier things to do. But in practice, though, the first bullet there, if you can't show the national importance of what you're doing, then you're probably not going to be able to show the third one because it's a national benefit to the U.S., but you already weren't able to show that. Well, I can't show you how it's going to benefit. The work is important nationwide. That doesn't mean it has to literally be nationwide. Um, Sometimes, like this isn't. There was a case where an old case called NISTOT, New York State Department of Transportation, where the work was going to be highways in the state of New York, but since the highways are connected to the intrastate highways, that was good enough. So it doesn't have to be a huge, but you got to show somehow this has national importance beyond my company, beyond just this area, that kind of thing. Let's go on here. Yeah, did that. Okay, so for both of these, you need to be aware of the adjudicator's time constraints. Most adjudicators do not spend, and they can't spend, not only do they not, they simply cannot spend more than 30 minutes reviewing your case. That sounds crazy, right? You got huge file, all these letters, you spent, weeks, months putting it all together, 30 minutes. And so how can that be, right? Well, they have a lot of these. They have not so much quotas, but like production goals. It's really not, it's really 20 minutes is probably pretty common too. 30 is the max. So again, you want to make their job easy. You want to help them to move on to their next case. And if they're having to pick apart, 30-page letters and then go find that stuff, the references in the file, deeper down the file, that's going to eat up a lot of their time. And I think I don't know, I don't want to say that they don't do their job well because that's not the case, but they need to move on. And so they'll end up finding a couple of things in there that are questions to them, and you might get an RFE, you might get a denial because of that. It's easier to do that. So you want to make it easy for them. I can't say that enough. Make it easy for them. Rather than having a big long letter that talks about all the different ways that you believe you meet these criteria for either of these, I think it's helpful to just have a very brief summary, like say a couple of pages, a few pages. I meet this criteria because I did this. And then the next one, I have this because I published here. The merit is there because here's the connections. And then refer to evidence later on in the file there. If you want to go look, Mr. Adjudicator, Mrs. Adjudicator, if you want to go look and see more about this, here's where you go. And then in that other part, you can get into the full explanation, the full argument. But now they know where you're going, and they know what the gist of your argument is. Um, they start off the file with a 30-page letter immediately. It's like, oh. Yeah. So people think, again, this is something that seems like common sense to do a long letter because you want to make sure you are thorough and you get everything out there. But it doesn't help the adjudicator. So put yourself in the adjudicator's shoes, I guess you could say that. Same thing with some of the other letters you see. Everybody knows, of course, obviously they're going to be self-serving. You wouldn't ask someone to write a letter, and you wouldn't include a letter if it was going to be negative, of course, right? I mean, that's basic. So they know that. And instead of just having somebody who's like a big name in the field or something like that, who doesn't really know your work, basically just say what you told them to say, like, oh yes, his work is great, and he's the top of his field, and I'm confident that he'll do amazing things or whatever. Well, they know it's more important they to have people who know your work. If you could have somebody really important who doesn't know your work, or somebody middle important who really knows your work and work with you, it's better to do that. And then they can talk about, well, we worked on this project, or he did such and such on this project, and it really affected the field because then people started doing this different thing as a result of what he produced, that kind of thing. Where it's concrete, it's examples. It's not just general statements like, oh yes, he's definitely one of the best and whatever. But you get that a lot. You get, so, I mean, if you're going to go to the trouble to have these letters, make them, you know, make them good. Okay. Let me get a sip of water here.
Hi, Avery. Sorry to jump in real quick.
Yeah.
We just actually got a great question from the audience. Someone is asking, what's your insight about the policies related to OPT and H-1B, since we're talking about EB-1A and EB-2 NIW?
You're saying that, I mean, I don't want to get into dialogue right now, but like, is that the upcoming changes, or is it like existing?
Because recently we heard a lot of news about like government seems gonna straighten on OPT, H-1B. There are gonna be some salary change standard. So
Yeah.
there's a lot of thing going on in these two parts right now, and people just wonder what's your opinion about the future of H-1B and OPT.
Well, there is a slide later on in the deck that we're going to get into that in good depth. So I kind of wanted to save it for that. I don't want to get off track and remind me, or actually whoever the person was who asked that question, when I get to that slide later, if it didn't address what you're asking, uh, send another message and we can get into more depth there. Is that okay?
Yeah, sure, perfect. That's
Yeah, okay,
perfect.
great. All right. So as alluded to here, we're going to talk about some of the changes and trends. And I don't know, I don't really have a crystal ball, but I do hear things. So, okay. So one of the big ones now, and people have probably heard this, is that uh, social media is being looked at. Um, they are looking at it for most applications. So I was surprised the other day they had a document out um, talking about this policy, and they specifically listed the ones you see here. So citizenship, adjustment of status, advanced parole, I-29 is the EB-5, right? Um, and the I-140, which is, of course, the what you'd be filing for an EB-1A or for an EB-2 or any of the EB permanent or family-based, for that matter, like marriage or whatever. They're looking at all that, and it's a long list, and I don't have it in front of me, but even some of the I guess platforms that are not U.S. based and don't really have a U.S. presence, they're on that list. Um, so and they're going to be looking for because they have a lot of discretion to deny things. They like to say they have more discretion than they really do, but a lot of things can be discretionary. So they're going to be looking for anything where you said something that's perceived as, you know, anti-American, anti-Semitic, or other kind of negative statements. So if this is you, you should make sure you, before you file anything, clean up your social media. I don't recommend deleting everything because then that's going to look suspicious. I don't recommend starting a new, a new, ID or something because then it's going to, wait, you just got this, right? So just clean it up. Um, they're also going to be looking at the entire history for an individual, entire immigration history, sorry. Even if it's really not something that's directly a requirement or directly relevant to whatever it is you're applying for. They might look and see, well, 10 years ago, I don't know, you got a B1 or you did this change of status, and we don't, you probably shouldn't have gotten that. It was a mistake or we don't like that decision. And they'll use that downstream now for what you're doing and say, well, therefore you're not going to get this. It's not fair. Um, that there's not a lot you can do about it, but just be aware of it, I guess. If there's anything in your immigration history that you feel was, questionable or borderline or that kind of thing, be aware of it and, be ready to address it if it comes up. The other new thing that's happening a lot for H-1Bs is you're seeing a notice to appear while someone is in their 60-day grace period. I think most of us probably know when your H-1B ends, you get a 60-day grace period to wrap up your affairs, sell whatever you need to sell, get ready to leave, right? That kind of thing. But you can also use that period to apply to change status to something else or to file an immigrant petition, right? And then that would be what takes over in terms of your status. So to do an NTA during the 60-day grace period is, and I don't want to say it's wrong, but it's not a good procedure. It's not correct. It's premature, I guess, to say the least. Um, but the big thing to know there is if you get that, let's say you were planning on leaving anyway, right? I was going to leave next month, day 50 or something. Well, don't leave because now you've got the NTA, and if you leave while an NTA is active, pending, whatever you want to call it, you have deported yourself and has the same effect legally, the same weight as if you had been deported by a judge, been ordered deported by a judge. So don't do that. Stick it out. Worst case, or I don't know, say worst case, but you go back to the judge, you show up in immigration court when you're supposed to, and you say, hey, I'm in my grace period. They shouldn't have given me an NTA. I'm planning on leaving, just let me go. Or I filed a change of status application and now that's what's governing while it's pending and, an NTA is not proper right now at this stage. Because it's not. I mean, it just isn't. After 60 days, if you haven't left and you haven't changed status and you haven't done anything, you're just here, then, okay, that's legally appropriate. So that's it. But anyway, but a lot of people are reporting getting those. It's a problem. And then basically just anything that's in your file, they're going to look at everything more closely. Um, I don't know how else to say that. Like it used to be things kind of glossed over. And in the context of an adjudication, they still have time limits, like I was saying. So I don't know how deep they can really go, but they're trying to. Um, okay. And here you can see some of the recent approval rates. Right now, we're in Q1 for immigration purposes. We're in Q1. The fiscal year starts October 1st. So we're in Q1 of FY 26. Yeah, that's right. Okay. Gets confusing with the years. So this was the most recent numbers I have seen here, and these are from a private source, but EB-1A, you can see it went down. Not a ton, but still significant, 5%. It's probably going to go down more the next time we get a report. EB2 went down a lot, 67 to 54, and that may be because of the national benefit. The third prong that we talked about, if you consider the way this administration looks at this issue in general, you could see maybe that being a big driver. As well, you're not benefiting the U.S., right? Something to be aware of, and something here you see O1. It's kind of an outlier. It's I don't know how to explain that. It's a 93.8. One guess that I have, or one theory, is that given the adjudication environment and given the mindset of the current administration, maybe people are only the really, really good, the ones who are really, really sure of their O1 are the ones filing, and anybody who's at all not sure just isn't going to do it right now. That could be it. Although by that standard, then you would probably expect some of the other ones like EB-1A to hold fast also, because maybe not, because that one was always a reach anyway, right? It's the biggest reach for anyone, so maybe that's why they're still filing. I don't know. That's just me guessing. I don't know that, but from my experience, that's my insight. So yeah, now let's look at some of the future rules that are coming up. This one is called, and for anybody who wants to look, there's a thing, it's called the Unified Agenda, and it's available online. Every government agency puts stuff in it because that's how they give the public notice of here's what we're going to be working on this year or the next couple of years or whatever. So you can, if you just Google Unified Agenda, USCIS or any agency, it'll come up. So this rule, it sounds harmless, right? Because it's just saying, oh, we're gonna, ensure the integrity. We're gonna define some things, update some things. Well, that sounds pretty harmless, right? But we won't know until the rule is published. And again, given the current climate, it seems likely that any reinterpretation of these things would be in a more restrictive way. For example, I showed you the 3 and 10. 3 out of the 10 criteria, they could increase that. They could say 5, or they might say 4 out of 8. They could do something. They could change that. They could also maybe go back into the list of 10 evidentiary categories and say, well, to be a major media outlet, you must have a certain circulation. And whatever that is, it might be a harder standard than what you've got now, because right now there isn't anything saying what's major. Same thing for like benefit, substantial benefit. They can always just make those harder by defining them in a way that narrows their scope, their applicability. So those are the things they can do. Whether they do it or not. The good thing that I've heard is that this rule has dropped in priority. I think if you look in the agenda, it might say January of 26, or it might even say December of 25. That's not going to happen. If it happens at all, it'll be later next year. But a lot of time when things drop down the priority list, it takes a while before if they ever get back up to the top of the list. So that's good, and hopefully, knock on wood, it stays down there. Another one, and this is where I think we were getting to a while ago. Yeah, so, USCIS is working on actually 2 H-1B rules. This one is going to, when you look at cap exemptions there are mentioned, it probably will narrow the scope of the cap exemptions. Right now, if you are, let's say, working at a nonprofit or research, that's affiliated with a university, right? You can be cap exempt under certain circumstances. They'll probably narrow that or narrow what kind of university, what kind of research, what kind of things qualify for the exemption. Or um, they're definitely, I think, going to look at. There's been a practice by some companies, or one in particular, where they create an affiliation with a university, right? And the exempt employer will petition for the H-1B based on the affiliation, and they'll get it. And then, though, there's a thing called concurrent employment for H-1Bs, where you can have more than one job at a time as long as they're both approved. And the way that works is once you are cap exempt in the first job, the second job is also not subject to the cap because you're a cap exempt worker. And that's viewed as your secondary job. But what ends up happening is, say, Microsoft pays a lot of money to this group to get the worker on their, working for Microsoft. So then they end up spending, say, 5 hours a week doing research for the research institution, but they're spending 35 hours a week working for Microsoft. It's a big, it's technically within the letter of the law, it's legal, but it's definitely not what was intended. And they're aware of it, and I guarantee you that would be something they would work on. So things like that. Um, USCIS is also going to change the way that the lottery is conducted, and that's what somebody was asking about. Rather than giving everyone an equal spot, and I'll talk more about this in a later slide, it's going to favor higher paid H-1B workers. And of course, also the final thing down there is the 100,000 fee, which is obscenely high. Most of us, I'm sure we've all heard about that. It's being challenged in court, but it does apply right now. The good thing, and it's kind of odd. It's an odd loophole because the original proclamation didn't say this. The original proclamation just said it applied to new visas, a new visa. So whatever that means. But what they then clarified is that it doesn't apply to a change of status in the U.S. So let's say you come in as a B, legitimately, not just with it can't be totally a pretext. But then I want to be an H-1B now, right? I'm going to file a change of status. Well, you didn't have to pay the fee. Or I was an L or an F. A student actually would be a change of status, right? You're changing from F to H-1B. So it's odd that they would do that, especially given that they then further clarified. Suppose now, okay, well, you got your change of status in the U.S., but you need to travel at some point outside the U.S., and you're going to need the H-1B visa at that point in your passport to get back in the U.S. as an H-1B. So that means you're going to go to consulate, you're going to get the H-1B visa. You didn't have one before, right? It's not status, it's a visa, but it's a new visa. But now they're saying, well, yeah, then we're not going to charge you that even under those conditions. So that's great. I think that's wonderful. I don't know why they're doing that because, given their intent, it doesn't really make sense. So but that's just something to be aware of.
Efren, do you think that's a real loophole or just someone's negligence and eventually can fill that loophole?
Well, they can certainly change their guidance, so they could. Um, Given the original proclamation, which was vague, of course, but it just said new visas. To me, that would apply to every petition, everything that's new, right? That's not, and I don't know if you remember, there was the first couple of days there was a lot of confusion. Like CBP said one thing, and the State Department said another thing, and the White House put out like a tweet or something that said something else. And none of it was really that consistent with the proclamation. It was all slightly different. It was really hard to figure out. And then about, I don't know, a week later maybe, they put out what I'm saying now, that yes, this doesn't apply, to a change of status. And even when you get the visa, it still doesn't apply to change of status. I don't know why, I can't imagine why they did that, but it may have just been confusion. I don't know. But it's good that it's there. So again, like, that's all I can say about it is I don't know what they were thinking. It's unusual, but it's good. Let's see here. What's next here? And this is just a general point. Actually, let me skip this one. Yeah, let's go to this. So this is the rule that someone was asking about a while ago, which would be changing the weighted selection process. Right now there is wage, as long as you have the required wage, the Department of Labor says you need to have on the LCA, you're fine. It has nothing to do with whether you get selected in the cap lottery or not. It's a random process.
Mm-hmm.
Well, now they're going to take into account, assuming this rule, survives, they're going to take into account your wage level. So as you see here, your wage level 4, you're going to get 4 chances. Wage level 3, you're going to get 3 chances, and so on and so on. So you see up here in this top bullet, wage levels 1 and 2 have been 50% of petitions. So that's going to really affect people at those wage levels. Yeah, and even if you're going to be in multiple areas, let's say, one office is in Rochester, New York, and the other office is in New York City, you have to use the lower of the two. So that doesn't help you. So that's going to be, let's see. I'm trying to read my notes here. I was just talking, but yeah. Also, if a beneficiary is on multiple petitions, which does happen sometimes, USCIS is going to use the lowest offered wage. So you got 4 really high ones and 1 low one. They're going to use the low one. So that's something to know and be aware of. One of the estimates that I saw projected that for F1s, so I think the person who asked that question was asking about F1s, I think specifically, that it would be reducing the number of H-1B visas available for F1s by 7%.
Wow.
Yeah. So that's big. But there's also ways that companies, because it always happens, that companies try to, I don't know, gaming is a bad word, it's negative connotation, but manipulate the process, let's say. So, maybe a company can identify somebody as a computer programmer, instead of a software developer, or you can recharacterize it within a certain scope, obviously. You can't just totally change it. But you probably have some flexibility of how you define the criteria for a job, and you might be able to make it into a higher wage level. Of course, somebody still has to pay the higher wage level. But if it's just a matter of like your job description and the company otherwise could pay, that's something that might happen. Yeah, you can also do. Yeah, here we go. So the last bullet here, consider schools in smaller geographic areas. Because let's say, if you're at Stanford, you're probably going to be doing H-1B work in that area, right? It's a high wage level. If you're in, this doesn't make any sense. Sorry, this is backwards. It's larger geographic areas, not smaller. If you're in Omaha, Nebraska, going to the University of Nebraska, and then you're looking at H-1B jobs in Nebraska, it's going to be a lower wage level. So that's something to consider if you're looking at schools, you're looking for where to do your graduate work, those kind of things. Maybe schools that are easy to get into that are in higher areas. Higher areas. I can't get them. I'm sorry for that. But also when you're planning your career, I mean, everybody wants to maximize their salary. That's something you want to do anyway, right? Of course. But, that's going to be something you really have to think about at an earlier stage of your career. Like when you're still in school, when you're thinking about what major, you're thinking about what classes and where they're going to lead, what kind of internships, that kind of stuff. You got to have that ultimate goal in mind now is going to be
So
more
looking
important.
for the smaller geographic area. So
Yeah, yeah.
so
Um,
basically, looking for Nebraska, looking for area, Urbana Champaign, University of Illinois, those are the areas that seems to be much more attractive maybe in the future.
yeah. So yeah, so I mean, like the main point is just that there's things you have to think about now planning your academic career that maybe you didn't have to think about quite as much without having a weighted selection process. Um, let's see, let me go back now. Where was I? Yeah. So overall, what's really happening, as I've heard the term points of failure be used, they're increasing the number of times where something can go wrong. Points of failure. Oh, you forgot to do this form, or you forgot to answer this question. This isn't really applicable here, but for example, one of the new fees they did is for asylum, people with pending asylum applications. While it's pending, and some of them can be pending for a long time, there's $100 fee. That I don't know what it's for. It doesn't make any particular sense to me. But every year, that person has to pay $100 fee to keep the application going, as long as it needs to keep going. Well, somebody might have saved up a lot of money for the thing. They don't have $100 to spare right now, or they forget, or something goes wrong with the payment process, all kinds of things, right? But you've introduced that one requirement, and then there's multiple ways that might go wrong. And you multiply that by all the other things they're introducing. Now there's all these little things that can go wrong. And it's like, gotcha, we gotcha, right? So it's more important than ever to either have a good attorney who keeps track of all this stuff for you. You need to keep track of it. Do a spreadsheet, do whatever, but really know, okay, when I file this thing, I'm not done. There might be things I have to do in the future. There's a registration requirement that could be something. Change of address. You're supposed to change your notify, sorry, USCIS when you change your address in the US if you're not a citizen. Um, Maybe not everybody knows that, or it got lost in the mail, or you did it too late, that kind of thing. And just all these little things that can go wrong now. I mean, that's not a new requirement, but they're enforcing it now. So just keep those things in mind. Let's go back to some more changes here. Sorry, there, okay. There's a duration of status rule that is out there. It's basically would try to get rid of duration status for the groups you see here, most particularly students. As you probably all know, typically you're admitted duration status as a student, which means that as long as you're doing the things you're supposed to be doing as a student, going to class, that kind of stuff, you're fine. And it's not set to a specific time limit. It might take you 5 years to graduate, 6 years, whatever. As long as you're making progress and you're still going to class and doing all the things you're supposed to do, it's fine. Well, now what they probably do, I think the rule says they'll give you 4 years. So if you're a PhD student, it's pretty hard, I think, sometimes to do that in 4 years for some fields. If you're just even an undergrad, that means after 4 years, you're going to have to file an extension with USCIS, not with your DSO, but not with the school, normally the school, but with USCIS, you have to file an extension. Again, that's another thing that can go wrong. You might not file it timely enough. And I don't know what percentage of students finish in 4 years. I don't think most do nowadays. So it's going to affect everyone. Or maybe you can get done in 4 years. I don't know. The other rule here, oh, sorry, and the DS rule has something in there that's really important that isn't really related to students necessarily. I think they just needed a place to put it, really, is the deference rule. The deference rule, for anybody who doesn't know, is let's say I got an H-1B. I've been in H-1B for 3 years, and now it's time for me to file an extension to get my remaining, 3 years or 4 years or whatever. Well, deference meant that going back to that original H-1B adjudication, as long as there wasn't like a gross error, or the law or the facts hadn't changed, or things like that, uh, you lied, something like that, they will respect that earlier decision and say, okay, well, yeah, fine, here's your extension. We're not going to really go into the details, the merits of, are you really still doing, is it still a specialty occupation for H-1B, that kind of stuff. Are you complying? Well, those things. They're not going to do that. So basically, every extension is going to be, they're going to look at everything again, like from the beginning. So there's no guarantee, even if you had it before. So it's going to slow down adjudications for one thing, because now the adjudicators have to look at this, and previously they didn't have to. And it's also going to result in a lot more denials for extensions. So something to know about. Another rule that was published, was sort of a surprise. It was a surprise, actually. It was published October 30th. And that one's already in effect because they did it as something called an interim final rule. So it's basically final. Um, there was always an automatic extension of your EAD when you filed to renew your EAD. It was always 180 days. That would allow USCIS time to process it, and you didn't have to stop working. Several years ago, USCIS got very far behind and still is very far behind. They pushed that out to 540 days. So that's a long time. So once you filed your EAD renewal, you were good for at least 540 days or until USCIS adjudicated the EAD renewal, whichever came first. Um, Not only did they take away the longer period and leave it at 180, they didn't leave it at 180, they took it away completely. So now there's no extension when you file your EAD renewal. That's going to affect a lot of people, and it's going to disrupt the labor market, because now you're an employer. I lose my employee because his at work authorization expired and he doesn't have any extension, or at least not yet. Um, and most employers aren't going to wait around a year or something like that, until USCIS approves it and now hire you back. It seems unlikely. So that's a really bad rule. It's really negative. The earliest you can file an EAD renewal is 180 days before your EAD is set to expire. So definitely do that. Don't do it on 179 days. Do it 180 days. But even then, that's just not going to be enough time in many, many cases. So it's going to be incredibly disruptive and, frankly unfair. Um, and then we mentioned there's a new rule coming out. It's going to be the STEM OPT rule that somebody was asking about. And it will very likely eliminate OPT and STEM OPT. If it doesn't eliminate it, like if legally I think it's questionable whether you can just completely eliminate it. They might narrow the categories of STEM fields. They might shorten the periods of OPT. Uh, they may change the approval criteria, things like that. But it's definitely going to be narrowed down. But if they can find a way to get rid of it, that's what they're going to do. So bad
So
news.
very likely we will not hear OPT again.
Um, that's how it looks. Yeah, I mean, hopefully there's some kind of OPT still left, but yeah, that's really bad. And that's of course a big
And
pipeline.
that's quite bad for the students, for international students.
Oh yeah,
That means they have no chance to prove themselves in order to receive, any kind of sponsorship in the future.
Yeah, because that's a big pathway to H-1B,
Yes.
obviously.
Yes,
Obviously.
no employer in their right minds going to sponsor anyone to H-1B, without have a test period, in the OPT period.
Yeah, I mean, it's unlikely, but maybe depending on your field, you might be able to get in. I don't know if there's something that's really high demand.
Very
So
few, very few demand, very few
yeah,
area.
yeah. So
And with
that's hate to ruin everybody's morning, depending on where you are or your night. But yeah, that's a really bad one. Um, okay, here's another one. Biometrics rule. That was published on November 7th. You can look it up. Basically, what it does is just going to be a lot more types of biometrics that DHS will collect, and it's going to expand the people that they would collect it from. So if you're a sponsor, if you're the spouse, if you're maybe if you file what's called an affidavit of support, which I don't know if everybody knows what it is, but it's just saying like, hey, I'm going to help cover this person because that way they won't become, what they call a public charge. All these people now they're going to say, well, you're going to have to, right now you can see on this third bullet, it's really only used in enforcement contexts, of course, like when you're arrested. But it's basically naturalization, filing for permanent residency, asylum, and the EAD. But now, if you see that final bullet there, that's a quote. Every individual filing or associated with, and that's the broad term, with any kind of request is going to be subject to it. And DHS might exempt some people, but it's going to be much more intrusive and much more, well, I guess intrusive in terms of the scope, how many people are subject to it, but also what they're collecting. I mean, to me, that's a little bit scary, voice prints, facial imagery. I mean, that's, wow. So hopefully I mean, I'm sure that'll be challenged. Hopefully that goes away. Uh, sorry. There. Here's a good one. Here's some good news for a change, right? If you look at the EB-5 rule, that was published on October 23rd. Basically reset the fee structure. This isn't displaying properly on the screen, at least on my screen. But you can still see on the left there, the change in the fees. On the table on the right, you can see what's supposed to be there, which is actually you can't, the difference. But you can see that they've all gone down. There's a new fee for this 956H over there on the right and 956K. That one's kind of big, the 956K. But otherwise, the good news is that most of these, not all of them, but most of these have gone down a pretty good amount. I see, yeah, it's basically the 956, the regional center application that's gone up.
Yeah, EB-5 is a special interest group. You always have a special interest group behind it and try to support the program. This is from the IUSA lobbying effort.
Yeah, no, and it's a good, I think before the previous administration, they were using some of the fee increases in EB-5 to fund other things. Like, for example, asylum, they don't pay a fee. It's free. Stuff like that, so they had to cover it. Now that's not going to be the case anymore. EB-5 fees are going to be used only for EB-5 program. So I think that's a big thing that led to this reduction. So, it's good news, right? Good, finally some good news for EB-5 world. Which leads me to this. EB-5 is a very good option. If you have access to the necessary funds here, I don't know if people know, you can borrow that. You can borrow some or all of it. And Jenny, I think you guys are a lender for that, right?
Yes, we
Yeah,
are, any people interested in that can come to us.
yeah,
There are very various way you can borrow from your 401k, borrow from your retirement plan, and you can also borrow from the house you bought, if it has equity inside. And some consumer consumer lending groups also has interest to provide the EB-5 money. If you have some interest, you can always come to us and ask those questions.
yeah. So also, as you see here, there's no wait for certain projects. That includes China and India, which are usually pretty backed up, obviously, in the other categories. Depending on the project, I assume, or not assume, I know, depending on the project. And then you're protected. A lot of the things that would maybe be a problem, say for an EB1 or family-based, like previous denials, or say maybe you worked without authorization, things like that would normally bar you are not always an issue for EB5. So it's beneficial in that way. Of course, the money is the big hurdle, but if you can do it, um, it's a good option. So that's the end of this. And now we're in the question part of this. I am going to stop sharing my screen. And now
Yeah,
we're back.
actually, I remember that one client is asked for about one audience is asked about what's your trend for what's your view for H1B and OPT. It looks like that's the immigration's USCIS priority to set the rule to restrict, right? In OPT, both OPT and H1B will be under a strong scrutiny, and even the H1B number will be cut. So that tells, it's really serious for the regular route for a lot of foreign workers, including a lot of international students want to stay in US.
Yeah. And I should probably clarify if anybody in the audience is currently an F1 and is either on OPT or is about to be on OPT, or is, I should say is, not about, is on OPT. I think it's unlikely that a rule would affect people who already have it. So it probably would be, I guess, what they call grandfathered in, because I think that the legal analysis gets a lot different when you're changing people who already have it, as opposed to just saying no more. So if anybody out there is that, you can probably be a little bit less worried, I guess, than the rest of
Yeah.
us.
The trick is that if you don't have OPT at this moment, you are eligible. Why not just apply for OPT? So just to go before the rule get hit, right? It will be eventually grandfathered. Why not just to go and apply for OPT first? Just make sure you get that, right? So this is
Yeah,
some tips,
yeah.
probably anyone can do, especially when enter the winter time. I saw some questions, someone raised hands, and let me see how I open it. Do you know how to open it? For
Yeah, I can just say the questions right now. So someone gave a really good question about given the 2025 revisions to Form I-129, sorry, adjudication standards, what new compliance risk should employers anticipate in areas such as employee relationship documentations, especially occupation justifications and worksite verifications? This is a very specific question.
Is this, do you know if they're talking specifically about H1B or is it in general?
I think it's talking about H1B.
Yeah, H1B. Okay, all right,
Yeah.
okay.
Actually, being employer, it's too much headache for all these new documents. I also read certain revisions, potential for revisions, and for site visits, occupation verification, work site verifications, and it's added a lot of burden being employer. So
Yeah.
basically, it's a
Mhm.
scare the employer away from H-1B.
Yeah, I mean, H-1B compliance is already difficult, and it's a lot of record keeping and that kind of thing. Um, and like you said, they're definitely increasing the frequency and amount of site visits. They're hiring more people to do them. Um, I think in practice, before, because of resources and whatnot, um, you probably there was a low chance that you would get one unless somebody had complained, say a disgruntled employee, or there was some other maybe pattern of questionable cases or whatever. Now I think there's no guarantee of that. If you're doing everything right, um, there's still a higher likelihood that they're going to come to your door and ask to see everything. So from the employer end, uh, you really want to check everything now. If you need an immigration attorney to do that, like you got to. I'm not an expert on H-1B compliance, so I'm not suggesting me, but you really want to get all that right. So yeah, there was a question in the chat, I thought, for everybody. Who was it?
Yeah, how long is the timeline are we looking for? Are we looking at for removing OPT and H-1B? When the change we're likely to implement it?
Let me see if I have it here in my notes.
That's someone put on the chat channel, webinar chat, and
Yeah.
we also have a guest questions on the Q&A session.
Um, if I remember correctly, that was, I think in the unified agenda, it might have said January, but those things tend to slip. But it'll definitely be, I think, in the first half of next year.
So it's not much time going to
Well,
left for
well, what'll
OPT.
happen though, I mean, there's a little more time because this will have to be what's called a proposed rule.
Mm-hmm.
So they propose it, and then the public is going to get 30 or 60 days to comment on the rule. They're supposed to consider the comments um, and evaluate them, and then they do a final or an interim rule, which then addresses those things. It says, well, here's why we're not going to change it, even though you said this, or yeah, you had a good suggestion, we're going to change it, or whatever. And then when that rule gets published, that's when it actually takes effect. So the period between the proposed rule and that uh, used to be a lot longer. It could be like 8 months. Now I think because if they're in a hurry, they're going to shorten it. It might be less than that, but they'll work faster, I guess I should say, more quickly. But I don't think you would see anything officially, in effect before like the middle of summer, and probably a little after that.
Okay, and another question, can a petitioner with an approved EB-1A adjust his status if he was inspected and paroled to the country? Because there are two opinions that state parole is not a status and cannot be considered as admitted. However, INA states they can. I think INA stands in the previous name for USCIS.
Oh, that was INS. Yeah, but that INA is the statute, the law,
Okay.
the Immigration and Nationality Act. Yeah, no, it's been traditionally parole is not seen as an admission to the U.S. The way to think about it is like, let's say you arrive at the airport, in San Francisco, whatever airport, um, and you ask to be admitted, right, to the U.S. under any kind of basis. You ask to be admitted. What parole is basically is you're still at the airport. You're still waiting for someone to tell you, yeah, okay, we're going to admit you. So, I mean, and of course, it's not practical for you to spend 6 months at the airport or something like that, right? Or even longer. So that's what parole is. It's like you're physically here, but you're not admitted. You're still legally, you're still at the airport. And that's always been the way that it's been handled. Under the, it may have been also under the Obama administration, but definitely under the Biden administration, they tried to be more generous with that. And for certain types of adjustment of status, they did consider a parole to be an admission. So it wasn't an admission like in general, but it was an admission for the purposes of adjusting your status. And not all adjustments, only certain ones, certain categories, certain bases. Um, Obviously, now this administration doesn't look at things the same way. So I doubt that's the case now. So, in the question though, I think you were saying you you were paroled in, and then while you were here under parole, you got an approved I-140 petition, and now you have that, and you'd like to adjust status, file a 45. That's what I'm understanding. So yeah, that wouldn't be. I don't think you could, is my answer. I mean, of course, I don't know what country you're from or how hard it is to travel or whatever, but the alternative there is that you just have to go process an immigrant visa at the consulate where you're from, and the wait can be long sometimes for those, obviously, appointments. But then you'd come back and be admitted with the immigrant visa, and at that point, when you're admitted, now you're a lawful permanent resident or green card holder when you're admitted. But that's probably the way that would work.
Well, the third question said, I raised my hand. John Oliver talks frequently about the changes in his own humorous way. But overall, it definitely seems to be an effort to limit immigration even more. So the sooner people apply for anything, the better. Don't you agree?
Yeah, I mean, in general, I would say that's a true statement. Yes.
Yeah, I know we do not have a crystal ball, but what are the chances these laws are changed with the new administration? Because they very clearly seem to be unfair and almost discriminatory to the large countries without more applicants,
Yeah.
or larger countries with more
With more. Yeah.
applicants, like China
Right.
and India. Is that true that every country is allocated a certain amount of applicants, no matter the population of the country? Correct? I think she was talking about 7% per country kind of limitations.
Yeah. For let me phrase this the right way. For non-immigrant visas, there's no. It's not relevant what country you're from, except in the cases of like I mentioned the Australian thing, or for an E2 a treaty investor, you have to have shared nationality with the country that the company's in, that kind of thing. But except for those situations, it's not a factor. Where you're from, or where you live, nationality, citizenship, all that stuff. For immigrant visas, there used to be what we call per country quotas, and that was a case where Latin America would get X amount, and Asia would get X amount, that kind of thing. Europe would get X amount. That's not the case anymore now. It's just by how many people. Well, yeah. So I get what you're saying now that I say this. It's going by how many people have applied. And that's why you always see on the visa bulletin, China and India are further back than what they call all other countries, which is global, because the big majority of them are coming from there, so they're going to be more backlogged. Um, yeah, so it does have, I guess it does have that effect. I don't know what else I can say about it. I don't, Yeah, I don't know if it was meant to be discriminatory or not. I don't think that was. That's a pretty old rule, although certainly it can be used that way now, I guess. Yeah. Do we have more
And
questions, I think?
yeah, and someone asked like, what is the process for someone applying for an EB-5 visa from outside the United States? Would that process take longer compared to applying from within the US? Also, would you recommend entering the US first and then adjusting status before any timeline of visa validity expires?
A couple of things there. First of all, even if you adjust status, a visa has to be a visa number, the slot, whatever you want to call it, has to be available, what they call immediately available. So it wouldn't make a difference, basically. If you're adjusting status in the US and you're from India or China, it's still going to be a long wait for visa availability. But the good thing, the different thing is you're here, and B, while your 485 adjustment is pending, you get work authorization. So, it's pretty good, right? Whereas,
Yeah.
whereas if you're in India, in China, you have to wait there. So it's definitely better to be here and adjust, just for that reason alone. But in terms of how long it's going to be before you can get the status, it doesn't really change it. In terms of, you asked about the EB-5, um, the process would be the same in terms of making the required investment and getting your petition approved, all those sort of things. That's going to be the same. It's the second step once you've got the visa, the immigrant visa based on EB-5, then again, like we were saying, you'd either adjust or you would come in from the consulate. So it's basically the same. And Jenny, you can jump in if there's something there that's not.
Yeah, that's true. So you actually, like Efrain mentioned, apply the US, give you a lot of advantage. You can adjust the status right away, get working visa and advanced pro, pretty much treated like a small scale green card. Other than that, if so someone, has children, if they are in the age out situation in the US, when you apply, adjust the status, you can lock the kid's age, So in that case, you are not facing the, toughness, by waiting in line. Your kids will always stay at the age they applied for EB-5, until the date actually, you received green card. So that's a pretty good advantage over a lot of you apply in your own native country.
Yeah, that's a good point. I forgot about the age outs. Yeah.
Yeah.
And since we're talking about the EB-5, I actually got a few questions from WeChat channel. Someone is asking, how can I participate in EB-5? I've heard it's becoming harder these days. Is it the right time to join now? And someone even asked, what's the EB-5 timeline? So it seems like some people, actually a lot of people, not really clear about the EB-5, the total workflow. So could Jenny or Efrain share with us how the EB-5 actually work to help our investors get the green card?
Yeah, Jenny,
Well,
that's yours.
well, the timeline actually right now, it's current, the visa, EB-5 visa for like Efrain mentioned for China and India are current. Now it's a great time, especially if you are in US. You apply for EB-5